right, I'm going to call Charles Schmidt, 25M4346. And Mr. Schmidt, if you could take a seat at this table. All right. We are set for a motions hearing today, and I know that the prosecution has objected to the court addressing these motions, but based on the record, I will allow for argument and, if necessary, testimony regarding those motions. So I think we'll just take them one at a time. I think it makes sense to give each party 3 minutes for the non-testimonial motions to make any argument that you feel you'd like to make on that issue. And then, so I'll hear from the defense because these are your motions. I'll give you 3 minutes, and then I'll give the prosecution 3 minutes, and then I'll rule on those motions. And then we can go from there. Do you have any questions, Mr. Schmidt, about the process we're going to follow today?
No, ma'am.
Okay. All right. So let's see. So there was a motion for I'm going to make sure that I'm keeping a real good record of this. So I just want to make sure there was a motion for an interlocutory appeal that you wanted to appeal that to a higher court, some of which I think was discussing that you were unhappy with the Judge Burbach's rulings on whether you would get that addressed. Do you still want to make an argument regarding the motion for an interlocutory appeal?
Yes, ma'am.
Okay. All right. I'll give you 3 minutes. Go ahead.
What was the charge that I was pulled over for?
So I mean, this isn't going to be a back and forth. So you can make an argument, and then I'll hear from the prosecution, and then I'll rule.
I have no idea why I was pulled over.
Okay. Do you want to make any other argument on this motion for an interlocutory appeal? You have about full 3 minutes.
The fact that I was not being represented by Constitution. I do have co-counsel with me at present, who is a bar attorney and my tribal elder. He has a federal bar card.
I'm not going to interrupt you. I'm just going to let you make any other arguments that you'd like. So you have about 2 more minutes to make any other argument. I'm going to take each of your motions one at a time.
And the fact that the officer lacked probable cause on the stop to start with.
Okay. Any other, I'm taking your motions one at a time, so I know you filed a motion for lack of probable cause. We'll address that. But if there is just this motion of that you are arguing you'd be entitled to have what's called an interlocutory appeal, which means we pause this hearing and then you'd appeal it up to a higher court. That was the first motion that I saw that we needed to address. So if you don't have any other argument on that, then I'll hear from the prosecution, although you do have an additional 1 minute.
I yield to the prosecution.
Okay. Mr. Eads, do you want to make any argument?
Your Honor, I just object to an interlocutory appeal in this case. I don't really think that there's any grounds. Generally, interlocutory appeals are reserved for when there has been some kind of order of the court, oftentimes like a prosecutorial motion based on like suppression of evidence or something of that nature. That's not really what we have here. I don't see that there is any real basis on which a interlocutory appeal would be warranted or necessary in this particular case. And I simply don't think there's any grounds for this request.
Okay. Based on my review of the authority, I don't find that anything has been presented that would allow for an interlocutory appeal based on the rules that are related to the interlocutory appeal. Let me just pull that up real fast.
May I say that my constitutional rights were violated, which state that in the interlocutory appeal.
Okay. Yeah, I'll let you make a record on, because I think there's some more specific ones that you've raised that I'll let you make that argument. Right now, I'm just looking at the rules of criminal procedure, and I'm just going to pull up that rule so we're all on the same page about it. So there was a repealed interlocutory appeal from county court. That was appealed in November of 1992. So I don't think that's good law anymore. It used to be able to have sort of an interlocutory. We're in county court right now. And that rule has been repealed. So the legislature says we don't have an interlocutory appeal on for county court cases. But then when I'm looking at, so there is an interlocutory appeal that you can raise in 41.3, the rules of criminal procedure. And there is an appellate rule. Let's see, but that really relies on, there's a statute for prosecution to file an interlocutory appeal under limited circumstances, and that is a statute that's 16-12-102. It provides that the prosecution may file an interlocutory appeal in the Supreme Court from a ruling of the trial court, but that's different here because it's the defense. Colorado Appellate Rules 4.1 implements the statutory framework for interlocutory appeals in criminal cases. Under the Appellate Rule 4.1a, the state may file an interlocutory appeal from a district court order granting defendants pretrial motion. So at this point, I just don't find that Mr. Schmidt is entitled to an interlocutory appeal based on the record before me, so I'll deny that motion. All right, so it sounds like that, Mr. Schmidt, you may want to discuss your, let's see. I'd like to do this in order though, so that we are, all addressing it. So I don't want to miss one. So the next one that was filed, and I promise we will get to your motion for regarding probable cause or reasonable suspicion for a stop. But the next one is mandatory judicial notice of parameters of judicial immunity. This doesn't look like it's necessarily a motion, just that it's kind of stating the facts of that case. But Mr. Schmidt, did you want to supplement the record at all on that particular filing? And I'll give you 3 minutes.
I apologize. I'm trying to locate it.
Sure.
What was the title?
The title was
Mandatory judicial notice.
Mandatory Judicial Notice of Parameters of Judicial Immunity.
It's basically stating that though issued in excess of his jurisdiction, it was not issued in clear absence of jurisdiction.
This is based on the actions of the guy who recused himself. Okay.
This is based on Judge Burbank.
On Judge Burback's, do you think that it's something we still need to address today?
Yes, ma'am.
Okay.
I most certainly do, because he's denied everything that I have presented, including the 8 motions. He said on the record that he denied when he did not. The record will show the only thing that he denied was a notice back in December, and that's it.
Okay. You have about 1.5 minutes left if you'd want to make any other argument on this one.
He denied all of my motions without the plaintiff entering any information whatsoever. He also entered a plea on my behalf without my consent against my objection, written objection, which he denied.
It's not entirely clear to me what is being requested in this particular motion. I understand this is more of a notice than a motion. I think at this point, seems based on the expanded record here that much of this kind of did hinge on the refusal to previously hear and allow for argument regarding these particular motions that were filed. I think that this is any kind of action requested may be moot now, given that we are here today hearing these motions. I don't really have anything further. If the court is looking for any kind of particular argument regarding any particular points, I'm happy to provide some further argument, but I'm not seeing any particular requested like resolution or anything of that nature in this.
Okay. Just to be clear, you have like 2 more minutes. If you'd like to make another argument, it sounds like that you do not. So what I guess I will say is I read that motion, and what I would just note is that I think any error is remedied by today that we're addressing all of the motions that have been filed. So I'm taking them one by one. So even if there was error where I'm ruling on them today, I'm giving you that opportunity to be heard. I'm giving you that due process. As far as the entry and not guilty plea on your behalf, the law does allow a judge to do that. There's a statute, and that's under Colorado law, and that's 16-7-208. Okay, so I know you object. I'm just gonna, so I've given you a chance to speak, I'll speak, and then, and you can make any other further record. But that statute says that if a defendant refuses to plead, then the court shall enter a plea of not guilty. So the court has the power, the judge has the power to move a case along, even if someone doesn't want to enter into their not guilty plea. That is a process that under Colorado law we have. So it sounds like that has raised something for you, Mr. Schmidt. So I'll give you 2 minutes to make any argument on that.
I did not refuse. He did not supply a bill of particulars where I could make my argument in pleading to the court. I do not know what I was pulled over for. I was denied counsel. When I requested counsel, I was denied Miranda rights when I was stopped.
Okay. We will, I believe your officers are here to testify regarding those issues. Is that correct, Mr. Eads?
Yes, Your Honor.
Okay, because I saw someone, let's just so you know, I didn't talk to him. I just saw 2 officers go in there. And so I would assume that they were for this case because it's the only case that's set for hearing. We will address whether your Miranda rights were violated because you have raised that, whether there was probable cause for an arrest or under the Fourth Amendment, a detainer. And we'll talk about whether there is reasonable suspicion. So we will have a hearing on that today. So just letting you know that. As far as the, again, I think I made my record on that the court can enter a not guilty plea. And then, so we'll take up the next issue, and that is motion to dismiss with prejudice, lack of jurisdiction for fruit of the poisonous tree. So this motion talks about jurisdiction, and then it also talks about under the Fourth Amendment, there is this idea that if there's an illegal search or seizure, evidence that's collected after that fact is what they call the fruit of the poisonous tree. So I think we need to put those into 2 sections. First one is your argument for lack of jurisdiction. And then the second one, I think we can address with that hearing. But again, I'll let you have 3 minutes to make any argument on that, understanding that we're going to need to have testimony. I guess, let me back up before I have you make your argument. Under the law, a defense has an initial burden on a motion to suppress evidence based on constitutional grounds. That initial burden is pretty low. I read that that you're asserting facts that occurred that violated your constitutional rights, and that evidence should be suppressed. So by filing those motions, I do find that you have met your initial burden to have a hearing. So then the burden shifts to the prosecution to show that your constitutional rights were not violated. So I know we're kind of handling some other cases that don't take testimony, but I'll find that you have met your initial burden to have that hearing. That's what we're going to have today. So I can't really rule on the fruit of the poisonous tree because that's going to require the prosecution to call witnesses, but I would like you to make any argument regarding the lack of jurisdiction if you'd like to make that argument, and I will give you 3 minutes.
As I had stated, the doctrine established under Silverthorne Lumber Company versus United States suggests that initial traffic stop was and is illegal, in that evidence or citations resulting from that stop are tainted and should be suppressed. He pulled me over for obstructed windshield. I was not cited for that.
Okay.
So anything beyond that would be null and void in ab initio.
Okay. Are you what we call personal jurisdiction over you outside of the charges?
Yes, ma'am, I am.
Okay. Mr. Eads, do you have any response to that?
I am a tribal member.
Okay.
Is there anything specific that you'd like me to respond to as far as like just
Just
personal-
giving everyone an opportunity to speak. So if you don't have any response, you don't have to make one, but I'm just giving everyone 3 minutes on each issue. So
Thank you, Your Honor. I guess regarding personal jurisdiction, I'll simply note that Mr. Schmidt was driving on Colorado roadways at the time that he was stopped. He wasn't in Jefferson County, Colorado, or is alleged to have been in Jefferson County, Colorado at the time. This is a proper venue and proper jurisdiction for this particular proceeding to occur within.
Objection.
okay. Did you want to make any other argument?
I was not driving. I was not operating. I was traveling
Okay.
in my mode of conveyance that I'm entitled to have.
Right. So I'm going to make a ruling regarding this jurisdiction issue. So jurisdiction is used in this order, this finding relates to the power of a court to hear and decide cases involving violations of substantive criminal law and impose punishment upon conviction. And that's People versus Verbrugge, Verbrugge. It's 998 Pacific 2nd 43, Called Appeals Court case from 1999. In order to prosecute a defendant, a trial court must have one, subject matter jurisdiction, that is jurisdiction over the offense, and two, jurisdiction over the person. And I would just point to any appellate court to Chatfield versus Colorado Court of Appeals, 775 Pacific 2nd 1168, Colorado Appeals Court case from 1989, and People versus WETTER 985 Pacific 2nd 79, Colorado Appeals Court case from 1990. As relevant here, subject matter jurisdiction is conferred by substantive law and refers to whether a court has authority to try the particular offense. That's Horton versus Southers, 43 Pacific 3rd 611. It's called Appeals Court case from 2002. Generally speaking, subject matter jurisdiction exists if the offense is committed wholly or partially within the geographical boundaries of Colorado, or the act wherever committed causes a criminal result in Colorado. That is a statute of Colorado Revised Statute 18-1-201. And that provides that a person is subject to prosecution for an offense which he commits by his own conduct. If a person is subject to prosecution in the state for an offense, if the conduct constitutes an offense and is committed either wholly or partly within the state. So what is alleged is this offense was committed in Jefferson County, Colorado. And so I do find that there is subject matter jurisdiction. So let's talk about jurisdiction over you, sir, Mr. Schmidt. I'll give you a chance to respond, okay? I'm not going to argue back and forth, though, specifically because if you decide to appeal my orders, then we do need to make sure that there's a record that's clear. So if we talk over each other and if you tend to appeal me, we want to make sure that the record's clear. So I promise I'll give you a response, okay? Jurisdiction over the person refers to whether a court has authority to try a particular person. Physical presence of the defendant in court confers personal jurisdiction. That's Bell versus Bauer, and that's 606 Pacific 2nd 74 from 1980. County Court versus Richards, and that's 812 Pacific 2nd 650, and it's note 3 in Colorado 1991. That it is necessary to acquire jurisdiction of the person in order to sustain a judgment of conviction. The manner by which the accused is brought before the court does not impair the state's power to prosecute and the defendant or the court's jurisdiction to try to defend and impose punishment. That's Yellen versus Nelson, 680 Pacific 2nd 234, Colorado Appeals Court case from 1984. I also have some other cases. I think I already cited to Bell versus Bauer. And Habbard, Habbord versus People, 488 Pacific 2nd 554, 1971. DeBaca versus Trujillo, 447 Pacific 2nd 533, 1968. SELPH versus BUCKALLEW, 805 Pacific 2nd 1106, Colorado Appeals Court case Colorado Supreme Court case from 1991. Once jurisdiction of the person is obtained, it continues until final disposition of the case. So again, it's been alleged that this occurred in Colorado. Therefore, the court has subject matter jurisdiction. Mr. Schmidt is here in front of the court. The court believes that it has jurisdiction over him. To any point that there might be that he didn't contract or any sort of UCC, I didn't see that in there, so I don't think I need to make a record on that issue. The Uniform Commercial Code. And so I do find that we do have jurisdiction over Mr. Schmidt, but Mr. Schmidt, I will give you 2 minutes to respond to the argument.
authority do you have over Indians? I did not hear anything about Indians. Under Yakima Indian Nation versus Flores, 955, F. Sup. 1229, E.D. Washington, 12 of February 97. Former Governor Stevens guaranteed that all Yakimas shall have the same liberties outside the reservation to pasture animals on land, not occupied, and on land not occupied by whites, to kill game, to go get berries, and to go on the road to market. I am free to travel, ma'am, period, by treaty. And that would be the Treaty of 1855. And I don't know that I have that number in front of me. What was,
Tribe was recommended.
so where did y'all wind up with jurisdiction over us when our treaty was there before this was even a state? We were in the Northwest and recognized by the United States as treaty. Indigenous Indians. I am a member of the Pilchuck tribe. I'm being represented by counsel of the Kikialis Indian Nation.
Okay, any response, Mr. Eads?
No, Your Honor.
Okay. So let me just pull up another case. And I'm going to rely on there's a Colorado case, People versus Drew, 650 or 250 Pacific 3rd, 761. It's a Colorado Appeals Court case from 2010. And that talks about that these ideas that someone's a sovereign citizen, and I have a quote from a case that is actually a federal case that I find helpful in that guidance. Utah Department of Workforce Services versus GEDDES, and that's a 2013 Westlaw 1367025. That court said this sovereign citizen argument has been rejected repeatedly by courts. Simply by labeling oneself as a sovereign citizen, an individual does not immunize himself from the jurisdiction of the state or federal courts. Jurisdiction is a matter of law, state and constitution, wherein one's power is and not a child's game, wherein one's power is magnified or diminished by the display of some magic talisman or use of special seals or by the recital of special words, phrases, or arcane incantations. Even though a defendant may have a sincere belief that he is an alien beyond the jurisdictional reach of the courts, in that case, they found he is simply wrong. Courts have routinely found that sovereign citizen arguments are completely without merit and patently frivolous. Thus, an individual's belief that status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law. That's Charlotte versus Hansen, 433 FAPPX 660, 10th Circuit, 2011. There's a number of other federal rulings and state rulings. I'll just see Schock versus United States, 92 F Federal 3rd 11877 Circuit 1996 is one. Anyway, and to the extent that the defendant's arguing that he's a member of a reservation, so there's a case, People versus Luna, 683 Pacific 2nd 362. It's called Appeals Court case from 1984. It is true that the state court does not have power over conduct of Native Americans within the Native American country, whether or not conduct is special concern to the federal government. But in this case, the court finds that it was in Jefferson County. There's not any sort of federal land within this that the court's aware of or that's been presented that this is on reservation land or this committed on reservation land. So I do find that the court has jurisdiction. All right, I do know that there are some people waiting. I was trying to do this in order of the that has been filed.
Objection.
Okay, give me 1 second. I think what might make sense, and then we will continue on with these arguments, is to take the testimony regarding your motion challenging reasonable suspicion, probable cause, and your Fourth Amendment arguments, as well as your Miranda arguments. Is there any other constitutional issues that you want to make a record for?
Cross-examine my expert on tribal law, and I do hold an adoption document in my right hand that shows my adoption to the tribe. So earlier stated, the Pilchuck tribe. And as for sovereign citizen, that's an oxymoron. You can either be sovereign or you can be a citizen, but you cannot be both. I answer to God and God only.
Do you have any questions for this officer? You're going to need to make sure that you're speaking into the microphone. For trial, you'll need to stand so that the jury could see you, but today I'll allow you to sit if you're more comfortable, but I just need to make sure that you're getting picked up on that microphone. Okay, thank you.
Fine, ma'am.
You can even move that closer. It kind of
Cannot.
slides closer. Yeah, there you go.
I cannot remain standing.
That's okay. You can remain seated. I just want to let you know, today, sometimes the jury can't see someone. And so if you needed an accommodation, we had a jury here, we could talk about it. Okay, go ahead.
Officer, would you please state your name again for the record?
Chris Steiner.
Officer Steiner, are you allowed to violate the law in order to enforce it?
At sometimes, yes. If I had to
So
drive
you-
faster than the speed limit or something like that, yes.
So you're allowed to use an unmarked car for the sole purpose of pulling people over for a placard, where nowhere on it does it say remove while driving
Yes, I'm able to use an unmarked car to do traffic enforcement.
against federal law. Where was I stopped?
I'm sorry?
Was it a highway, a roadway?
You
Byway.
pulled off of Lamar onto, I believe it's
So it's-
56th.
So that is not a highway,
It's a roadway.
right? I believe I have something that says all Indians have secured treaty right to travel upon all state public highways without being required to have a state-issued driver's license, license plate, or registration. Are you familiar, sir,
Your Honor,
with,
object at this time to relevance as well as, I believe, a misstatement of the law.
So I'm going to let Mr. Schmidt finish his question and then I'll roll on your objection. So what is your question?
are you familiar, sir, with the Vehicle Anti-Theft Act?
So I'm going to find that that's not relevant to the issues of constitutional motions of whether there was reasonable suspicion to stop the car, probable cause, or the Miranda issue that's been raised. And so I will sustain that objection. Mr. Schmidt, today, all we're deciding are these constitutional issues of whether evidence can come into your trial. And so all we're focusing on is whether the officers complied with the Constitution. And so if Mr. Eads is objecting, I'll rule on those objections, but I want you to narrow in on those issues that you filed on that regarding those constitutional issues. Go ahead.
Officer Steiner, correct?
Yes, sir.
It is Steiner. Okay, I just want to make sure I'm correct. You say I did not offer you anything as evidence. Do you remember a blue folder that I handed you 3 times out the window? My dossier that had all that in it?
It was twice you threw a large packet of paperwork at me saying I'd been
3
served.
times.
Okay, Mr. Schmidt, you can't interrupt him because we do need to make sure the record's clear, okay? So go ahead, officer, and then I'll let Mr. Steiner finish his sentence.
Do you know what was in that dossier?
No, sir.
Did you open it and look?
It wasn't the driver's license, registration,
How do
or
you
insurance
know?
that I asked you.
Mr. Schmidt, again, you can't interrupt, okay? And so we won't get the record to be clear. So Officer Steiner, if you could just finish your sentence, please.
It wasn't the driver's license, registration, and insurance card that I asked for,
And how do you know this?
because you told me I was being served, which to me appears to be legal documents serving me with some type of like a court document or something like that. That's not a driver's license.
So you're saying that the seatbelt was the probable cause in order to pull me over?
No, sir.
Is that an arrestable offense?
I did not say the seatbelt was the probable cause to pull you over.
Okay, so it's a secondary.
Correct.
Okay, what was the probable cause in order to
In-
pull me over?
The obstructed vision that could have occurred from the object swinging from the mirror, that being the handicap placard, and the fictitious license plate on your vehicle.
Do you have measurement or a photograph of this alleged swinging ADA flag hanging from the rearview mirror?
I believe it was captured on body camera.
Hmm. And I bet it hangs lower than the sun visor that comes standard equipment with the vehicle?
Yes, sir.
No.
Because it hangs on the rear view mirror, which hangs down below the visor, sir.
Objection, Your Honor.
I'd like you to focus on any other questions that have to do with that stop, probable cause, or the Miranda issue that you've raised regarding your statements.
I had requested counsel to be present. Do you remember me making that statement? And that I did not allow for any search or seizures of that car? I made that statement to both you and Officer Brown.
I'm going to object. This sounds like testimony. He's not currently on the stand.
Okay. I guess I will rephrase that and just to kind of streamline something. Officer, did at any point he request an attorney?
Not that I recall.
Okay. Mr. Schmidt, any other questions?
Did you cite me for the other violation that I was alleged stopped for?
No, I didn't cite you for the handicap placard. I cited you for several other violations.
Which would be poisonous of the fruits of the poisonous tree. I yield.
Okay.
No further questions, Your Honor.
Any redirect?
No, Your Honor.
Okay, thank you. You may step down. Any other witnesses for the prosecution?
Your Honor, I do have Sergeant Brown here. I guess at this point, I'll just inquire, does the court feel that they have sufficient information upon which to make a ruling on these motions, or is there anything further? I do have Sergeant Brown here, but at this point, there is sufficient.
Objection, Your Honor.
And what is your objection, Mr. Schmidt? Well, it's your burden, Mr. Eads, but I don't have any specific questions.
He gave up his probable cause when he failed to cite me for the
Okay.
stop in the first place.
So I'll take argument regarding that. Are you intending to call any other witnesses?
Yeah, at this point, I think we'll rest.
Okay.
I do have Sergeant Brown here, but I think they're sufficient.
Okay, hold on a second, Mr. Schmidt. So the prosecution rests on the motions hearing. Mr. Schmidt, do you intend to call any witnesses that are relevant to the probable cause, the stop, and the Miranda issue?
Yeah.
Was that person present here on that day? Okay, so how would he,
By tribal counsel,
okay,
expert witness,
for what?
tribe matters.
Tribal matter, so legal issues?
Yes.
Okay.
Traffic in particular.
So I'm making a factual finding today regarding whether there was reasonable suspicion, probable cause in that Miranda issue. Calling an expert, a legal expert, I'm going to base my decision on the law. You can cite the law, but you do not have an attorney that has entered their appearance formally, and they need to do that before they can represent you. If he's an expert, you can,
Co-counsel, ma'am, do not have to according to the Sixth Amendment.
yeah, well, under the rules of the Colorado Rules of Procedure, you do have to have an attorney enter their appearance to represent you, because you can't practice law without asserting and filing the proper paperwork. So,
Neither can you, ma'am.
okay, I'm not going to argue back and forth. You've asked me to rule on these issues. So I am not going to argue back and forth. What we do is I allow you to make argument, response, and then I'll rule. I am declining to hear from your person that's here today. I don't think it's relevant to the motions issues that have been raised. So,
Objection, Your Honor.
okay, I'll note your objection. Now what I'm going to do is, do you have,
Ma'am, can either overrule or sustain.
okay, I note your objection.
You don't note it.
I will note it, and I've already said that I'm denying you an opportunity to have your witness testify. So you can make a record regarding your objection, but I've already said that I'm not allowing him to testify. All right. So I just want to make it sure it's clear, Mr. Schmidt, do you have any other witnesses that you wish to call?
Not that you're willing to allow.
Okay, thank you. All right, for the prosecution, any record regarding the motions to suppress that have been filed by the defense?
Your Honor, I guess I'll keep it brief. I think the record as it exists from Agent Steiner is sufficient to find that there was reasonable suspicion for the stop in this particular case, that there was, in this case, a primary offense that was observed, noting that that primary offense wasn't ultimately charged in this case. There was a primary offense that was observed, specifically the obstructed windshield, that was the basis for the stop, or for even the initial approach and sort of investigation following the vehicle, at which time he also observed another primary offense, which is that fictitious plates, based on his own experience, 30 years of traffic history, and 30 years working for the police department, observed that there were some irregularities with respect to the specific license plate that was seen on Mr. Schmidt's vehicle. So that was the basis for this particular stop. And ultimately, based upon the remaining contact that Agent Steiner had with Mr. Schmidt, this was a sort of combative situation. However, at no point in time was Mr. Schmidt in custody. He remained in his car. He remained in there with the windows cracked. Agent Steiner was trying to obtain information from him, but Mr. Schmidt was not very cooperative in providing the requisite information that he needed to further his investigation in this traffic stop. Ultimately, a packet of materials was sort of tossed out the window to Agent Steiner. It's unknown exactly what was in there, but the context behind it was that he had said, "You've been served." And so at no point in time did he ever respond to a specific request for the registration or for any proof of insurance on his vehicle, and continuously denied any efforts to verify the registration or insurance status on that vehicle. Eventually, he did provide proof of a Colorado driver's license. However, that is all he ended up providing during that traffic. And are there any other questions or legal issues that the court might want to hear argument on? I think the record has been laid out pretty thoroughly based on the testimony from Agent Steiner at this point.
I don't have any specific questions for you.
Okay, then the people will rest there.
All right. And Mr. Schmidt, I'm going to give you 3 minutes to make your argument. You have 3 minutes starting now. Thanks.
Yes, ma'am. I was not under a consensual investigation. I was under custodial. I was not allowed to leave. I was under arrest. At that point, I was not given my Miranda rights, nor was I allowed to have my counsel present at any questioning, which I refused at that point. I was not going to answer any further questions. Based on that, I would have to say that Officer Steiner gave up his right to charge anything other than the seat belt or the obstructed windshield because that is the primary reason he pulled me over. In fact, I asked him what his probable cause was, and he needed to articulate it, and he could not. He couldn't even give me a chapter and verse that it's sitting in. So to say that he had authority over me, he does not.
So about 2 minutes left. I'm happy to hear any other argument.
I yield.
I'm sorry, I didn't hear that.
I yield.
Yield. Okay, thank you. All right, the court's going to make the following findings in fact and conclusions allowed to rule on this matter. I guess initially, there's been some argument, so I just want to make sure that the record's clear on the jurisdiction of the court. I'm looking at 422126.5, and that is regarding some traffic laws, and it talks about that it uses the term Indians, means a person who's a member of a federally recognized Indian tribe. So Mr. Schmidt is asserting that he's a member of this federally recognized Indian tribe. What that talks about is that the traffic code. So the tribal code, including traffic provisions, governs the conduct of Indians within the reservation. When Indians drive, and this is a quote, and that's subsection 2.3. When Indians drive outside of the reservation, state and municipal traffic laws apply to their state driving privileges. So I'll just find that the court does have jurisdiction over Mr. Schmidt on this traffic case. So I'm going to read some case law into the record so it's clear. So the first question for the court is whether there was reasonable suspicion to pull Mr. Schmidt over. There are three types of encounters with police. There's the consensual encounter, there is the investigatory stop, and then there's the arrest. And that's People versus Walter 249 Pacific 3rd 805. It's a Supreme Court case from 2011. The test between a consensual encounter and one investigatory detention requiring reasonable suspicion is whether a reasonable person under the circumstances would believe he or she was free to leave in order to disregard the official's request for information. And so I think at this point, I think everyone's in agreement that this was an investigatory stop. This was not consensual. Mr. Schmidt pulled over after the police officer pulled him over. And so what I'm asked to decide then is whether there was reasonable suspicion. The reasonable suspicion standard requires considerably less than proof of wrongdoing by preponderance of the evidence and is less demanding even than the fair probability standard for probable cause. That's People versus McKnight, 452 Pacific 3rd 82. And that's a Colorado Court of Appeals case from 2017. It is satisfied if the police have specific and articulable facts greater than a mere hunch to support their belief that the person to be stopped is or may have been involved in criminal activity. An officer must have reasonable suspicion that the driver is violating the law in some way to conduct a traffic stop. And after that traffic stop, the officer may obtain identification and registration information from the driver in connection with that stop. That is People versus HJ, and that's 931 Pacific 3rd 1177, Colorado Appeals Court case from 1997. In this case, in that People versus HJ case, they actually talk about that someone having a license plate light was out is sufficient for reasonable suspicion. So traffic offenses can be grounds for a reasonable suspicion. And that talks about that, that's that People versus HJ case. The officer decided not to cite Mr. Schmidt for the obstruction. There's no law, and let me just pull that over to, let me just get this. There's no law that requires that someone be physically charged with whatever initially had created the stop. And what I'm relying on, I'll just look at, there is a case in which for example, People versus Burnett, 432 Pacific 3rd, 617. It's a Colorado Supreme Court case from 2019 that talks about mistaken interpretation of traffic law, must be objectively reasonable, support of finding reasonable suspicion. So even if an officer is mistaken regarding the reasons, it must be objectively reasonable, support of finding of reasonable suspicion. So the officer said that he thought that the obstructed window could be obstructing, although I think it's required under the law that it has to actually be obstructing, and I didn't hear that evidence. But then he also said that Mr. Schmidt had a false plate. He made an argument or a statement that Mr. Schmidt's license plate there was no record of that license plate at the Department of Motor Vehicles, and that it appeared to be altered. Let me pull up that language. It was not a standard plate issued by the state of Colorado, and it had Colorado on top and then some initials or letters on the side. The numbers weren't standard. The colors weren't standard for the Colorado license plate. And so he pulled Mr. Schmidt over for that false or fictitious plates. So I guess I'll just go into the facts that I heard. So Officer Steiner testified that he's a detective for the Arvada Police
Objection, Your
Department.
Honor.
Sir, I'll let you make an argument. It's my turn to make a ruling. That on August 1st, 2025, he pulled over Mr. Schmidt and he identified him as the person in the courtroom. He was pursuing a click it or ticket offense. He did see that Mr. Schmidt was not wearing a seatbelt, but that is what's called a secondary offense. So he didn't pull him over for not wearing a seatbelt. He found that he had fictitious plates and that he said that could be obstructed view. He pulled Mr. Schmidt over and then he didn't have a driver's license. He said he refused to give him his license, registration, and insurance. And he said that he wasn't his friend, so he wasn't driving, he was traveling. Mr. Schmidt wasn't being compliant, and he said he'd like to speak to Officer Steiner's supervisor. So Officer Steiner complied with the request of Mr. Schmidt and called Sergeant Brown. And Sergeant Brown then reported to the scene, and they talked for another 3 minutes, and then it appears that Mr. Schmidt then did comply with providing his license. He was issued a summons. He had failed to display a valid registration. He wasn't wearing a seatbelt. He didn't have proof of insurance, and he was charged with the obstructing and the fictitious plates. He did not accept the summons, so they put that under a windshield wiper. And so the court does find that there was reasonable suspicion to pull Mr. Schmidt over for the false plates. As far as the probable cause for an extended detention, I'll just read that into the record. So to be valid, an arrest must be supported by probable cause. An arrest doesn't have to mean necessarily that someone was put into handcuffs for the purposes of the Fourth Amendment, but probable cause to arrest exists when the facts and circumstances known to the arresting officer are sufficient to warrant the belief by a reasonable and prudent person in light of the person's training experience that an offense has been committed and the defendant committed it. And so probable cause is determined based on the information possessed by the officer at the time of the arrest. Just as an arrest may be validated by subsequently acquired information, it is not invalidated by subsequent events. In evaluating probable cause, the courts have found that it's the probability, not certainty, is the touchstone of reasonableness under the Fourth Amendment. And that probable cause involves probabilities similar to factual and practical questions of everyday life upon which reasonable, prudent persons act. That's People versus Thompson, 793, Pacific 2nd, 1173, Colorado Supreme Court case from 1990. I'll just note too that issuing a summons does not amount to an arrest, and that's Hart versus Herzig, and that's 283 Pacific 2nd 177 from 1955, excuse me. So to the extent, so I would find that Mr. Schmidt was pulled over, then he requested a sergeant be on the scene, which prolonged his detention. And so I would find that in essence, he was requesting it. However, I do find that there was probable cause in that he had fictitious plates, he was refusing to give his information, and then as they continued their conversation, he had failed to display proof of insurance. And while he received a summons, there was sufficient probable cause to place him under arrest. As far as Miranda, that's a different analysis in that there must be custody and interrogation Custody is more than not being free to leave. That looks like there's a case that says it's tantamount to arrest. And so the court finds that Mr. Schmidt was given a summons. He was not under arrest for purposes of a Miranda. Mr. Schmidt, I promise I will give you a chance. I need to make my record. A custodial detention entails a greater restriction on freedom than that associated with investigative detentions under the Fourth Amendment. Under the Fourth Amendment, a seizure results when a reasonable person would not have felt free to leave or otherwise terminate an encounter with law enforcement. By contrast, custody for Miranda purposes requires a suspect's liberty to be infringed upon a degree associated with formal arrest. That's People versus Pleshikov, 298, Pacific 3rd, 228. Colorado Appeals Court case from 2013. So the court looks at those factors and finds that he was not under arrest or custodial interrogation for the purpose of needing Miranda to be read to him. I find that he was not in custody for the purposes of Miranda. So he's not subject to custodial interrogation. I'll find that all of Mr. Schmidt's statements were voluntary. So I am denying Mr. Schmidt's motions on those issues. Mr. Schmidt, I'll give you another 3 minutes to make any argument regarding that because it sounds like you have some disagreements regarding that.
Yes, ma'am. United States versus Pratzer. If an officer does not cite based on what he pulled me over for, he loses his opportunity to come back at a later time and cite me for anything else. Furthermore, where's the corpus delicti? I want to see the person that I harmed or injured. Also, I would like to see the contract in which I have signed my signature to obligating me to this. And again, I will bring up the unmarked car. Where in statute or federal law does it allow an unmarked car to pull over another car? I yield.
Okay. Any response to that? Okay. I made my ruling regarding under the state law, and there is one more thing that I probably need to put on the record regarding travel, and that is, let's see, I just found that case. So while the right to travel interstate is without question a fundamental right under the Constitution, the critical inquiry in the case is whether someone's license burdens this fundamental right, and the Colorado Supreme Court has found that it does not. So requiring someone to be licensed or follow the traffic laws does not unconstitutionally burden someone's right to travel. So that's Henninger versus Charnes, Charnes, 613 Pacific 2nd, 884. It's Colorado Supreme Court case from 1980. All right, so those are the constitutional issues I believe that we have handled. There's a argument regarding your violation of your right to speedy trial. Did you want to supplement the record at all on that, Mr. Schmidt?
No, Your Honor.
Okay. Did you want to make any argument on that, Mr. Eads?
And I would just note procedurally, it looks like not guilty had entered on December 11th, 2025. So that was the start of the speedy trial. 6 months is what we calculate in the state of Colorado. So speedy trial I have calculated to run on June 11th, 2025, which would be before our currently set jury trial. So I don't think there's a violation of speedy trial.
Okay. I'll note that the federal speedy trial is actually longer than the state speedy trial. And so the state speedy trials that we're setting this within 6 months of your not guilty plea that I understand has been entered on your behalf, but I still think we're within the statutory requirements for speedy trial. Let me see if there's anything else that I believe we've already discussed the bill of particulars. Okay, I believe that we have addressed everything. Am I missing anything, Mr. Schmidt?
The fact that Speedy has already been violated, the moment that the officer issued the ticket began the clock, not from the time that somebody enters a plea on my behalf against my consent or without my consent and with written objection.
We're getting to 5 o'clock and I don't want staff to have to stay late. So I'm gonna just jump into that. it says under 18-1-405, if a defendant is not brought to trial on the issues raised by the complaint within 6 months from the date of the entry of a plea of not guilty, he shall be discharged from custody or the charges shall be dismissed. So it is the entry of a plea of not guilty that is for the record. Okay. I just want to confirm, Mr. Schmidt, do you still want to proceed to a jury trial on June 4th? Or did you want a trial?
Federal law states 90 days.
Okay. Well, we're under the state law. So I just want to confirm, Mr. Schmidt.
Objection, Your Honor, you're telling me that you supersede federal law.
I'm not going to argue back and forth. I'm making my rulings based on the state law. All right. So, Mr. Schmidt, I just want to confirm you are set for jury trial on June 4th at 8 a.m. Have you picked up your discovery?
Still object, Your Honor.
Okay, I'll note your objection. I've already made my ruling. I'm not arguing back and forth.
I don't need a note. I need either
Okay,
overrule or sustain it.
I've already made a ruling on it, and you've made a record on your objection.
No, ma'am.
No, we're not arguing back and forth. So, Mr. Schmidt, are you going to be ready for trial on June 4th? I guess we'll see you back here on May 26th at 10:30. Your case is currently set for jury trial. I want to make sure that you understand that you have a right to be represented. And so I'm going to make this record here today regarding what's called an Arguello advisement. It's under the state law, but do you understand, Mr. Schmidt, that you have a right to be represented by counsel throughout these proceedings?
No, ma'am, I do not understand anything, but I do comprehend everything that you have said.
Okay. Do you have any questions about your right to be represented?
I believe I've already answered that.
Okay. So these are required questions by law that I have to ask you, okay? Do you understand that if you cannot afford an attorney, one can be provided to you free of charge? Practically, I'll give you a chance to answer, but practically what that means is you have to make an application with the public defender's office. So if you wanted to be represented by the public defender's office, you would have to file that application with them. They would make a determination of whether you qualified. If you made below a certain amount, the public defender could represent you free of charge to you. Are you okay going forward today with, are you okay going forward then without an attorney? Okay. Do you understand that if you cannot afford an attorney, one will be provided to you free of charge if you take those steps?
Should I choose to do that? Yes, I understand
Okay.
that.
All right. And these are questions, again, that I'm required to answer by or ask you by law. Do you have any legal training?
Sure.
Okay.
Plead the fifth.
The 5th on your legal training. How far have you gone in school? Okay. So I need to just understand, do you feel like you have, I need you to answer some questions or else I'm just going to find that you are making a choice not to answer these. But I do need to make sure that it's clear that you fully understand it. And I know that you have these legal arguments that you would like to make, but you have a right to an attorney. And that's a really important right. So please let me finish and then I'll let you finish. But I need to make sure that I am getting the questions asked under the law and that you need to answer them. And so saying pleading the 5th, I can't tell if you don't understand the process. And so that's what I'm going to keep asking you. But if you're just trying to use it as a game not to answer the questions, then I can make that based on the demeanor. I do feel like it's kind of this game you're playing with your friend that's here. So do you have any legal training? Yes or no?
Yeah.
Okay. How far have you gone in school? Are you under the influence of any drugs, medication, or alcohol that would affect your understanding of today's proceedings?
Do not understand anything.
Okay. So I'm just going to make a record for any appellate record that Mr. Smith's sitting here with his arms crossed. He's clearly not wanting to answer my questions. I do not think, based on my observations, that he's not understanding. I've allowed someone here to sit next to him who keeps whispering in his ear. It is clear to me that this is a strategy. So I just want to make sure that that's clear on the record. But I do think that Mr. Schmidt appears to be understanding everything here today. He doesn't appear to be under the influence of anything. He's been able to coherently answer the court's questions, but I do just want to make that finding. Mr. Schmidt, do you understand that criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and representing your defense?
Understand anything.
Do you understand that criminal law is complicated? And do you understand that someone that's trained in the law could help you in preparing and representing your defense? Okay. Do you understand that you have a right to remain silent and that anything you say can be used you in court? Okay. And again, I'll just make a note that I'm trying to advise Mr. Schmidt. I hope that he understands this. I think he does understand my questions, but he's making a point of not answering. You should understand that you have a right to represent yourself, but by doing so, you take a great risk of not properly presenting your case. You have a right to confront the witnesses against you and cross-examine them. So again, what you saw today was cross-examination, what you participated in, but at trial, you can also do that at trial. Do you understand that, Mr. Schmidt? That's a yes or no.
Anything.
Great. And I'll just note, again, I do think that Mr. Schmidt is comprehending what I'm saying, but choosing not to answer. And do you understand that you have a right to have witnesses you choose compelled to appear and testify on your behalf? What that means practically is if you are representing yourself, what happens is you can go to the clerk's office, get a motion. If you have someone that you would like to be court ordered to be here to testify, then you need to fill out a motion, and then I will look at it and see if they're relevant to the case at hand. And if I do find that, then I will approve it. Then you'll need to have third parties not related to the case serve a subpoena. If you have witnesses that you would like to be here to testify, you'll need to endorse them at least 7 days prior to trial, and then you'll have to go through that process. Do you understand that, Mr. Schmidt? Yes or no? All right. I'll just know Mr. Schmidt's making a choice not to answer, but I do want to just make sure that this is clear. He's facing fictitious plates, and I believe that that's a traffic misdemeanor that comes with a maximum fine of $300, 90 days in jail. Registration is a traffic infraction. That's a maximum sentence of $100 fine. Seatbelt not used is a $100 fine. Failure to display proof of insurance is a maximum sentence of $1,000 fine, 1 year in jail. If you have proof of current insurance and that it's a mandatory minimum, $500 fine. If you have proof of current insurance, it's $250 fine. If it's a second or more, you're facing a mandatory minimum of $1,000 fine.
I need clarification.
Oh, hold on a second. I need to make my record, okay? Because I need to make sure you understand the penalties that you're facing. So you're facing a maximum sentence of 1 year in jail, $1,000 fine for that no proof of insurance. And then you will have a mandatory minimum if this is a first offense. Within 5 years, it's a $500 fine. If mandatory minimum, $1,000 fine if it's a second or more. Obstructing a government operations, you're facing up to 120 days in jail, a $750 fine. Do you understand, Mr. Schmidt,
I
the
do not
penalties that you're facing?
Understand anything.
Okay, all right.
Clarification. This
Sure.
goes for Indian tribal members as well.
What is your question?
This goes for Indian tribal members as well.
I've already ruled on that. I'm not going to go back to my ruling on that. All right.
What was that ruling?
You can order a transcript of the ruling. I found under the statutory requirements that someone that is a tribal member can be charged under the traffic laws. All right. So we'll see you back here. It is now, we'll see you back here on May 26th at 10:30. Any other motions can be filed in writing.
Objection,
Okay, thank you, sir.
I need my objection.
I've noted your objections. I've ruled on all of your motions.
That's not a ruling.
That's an ignore.
You're asking me to
You're
argue back and
ignoring
forth
what-
with you. Mr. Schmidt, you're asking me to argue back and forth with you. That's not how the court works. I've heard your legal arguments, I've heard responses, and then I've ruled. You want to continue this dialogue, and it's not a dialogue. I'm just ruling on it. I wish you the best, Mr. Schmidt. I'll see you back here for your pretrial readiness conference. If you need any information on how to get discovery, you should talk to Mr. Eads. There is a process to get what we call discovery, which is the evidence in the case. I am finding, though, based on the record, that's a knowing waiver of counsel, although that does not prevent you from getting an attorney and hiring an attorney or applying to public defender. If you want information on how to apply the public defender, I'm happy to give you that information. And we will see you back here for that next court date. Thank you, sir.
As his next friend counsel, I object to the fact that you refuse to rule on any of his objections. I find in the
you.
statute where you can sustain the objections, which I suggest you do, and I find where you can overrule those objections, which I know you will. Nowhere do I find where you can ignore or note an objection. It doesn't exist.
She
Get
abandoned,
away with it a lot around.
she abandoned
But in federal court, it doesn't.